Welcome to the channel where we make your insight to the Australian visa system. Good day everyone, my name is Cao Yang, your online YouTube visa consultant. Are you interested about migrate to Australia? Why don't you consider to subscribe to my channel and turn on the bell on the side, so once we have all the updates and news, you'll be the first one getting all the insight. Now, remember that the migration strategy plan and has provided a number of amendments, and especially with the skills in demand visa, which is going to replace the employer sponsor category visa by dissecting them into three different pieces. Now, we can see that the process of getting that new category visa will be out very soon, because there has been furthermore law being implemented now, not on the visa side, but on the employer, who's going to be the sponsor side. So all of this is a sign that the government of Australia is in the progress of moving towards a major trend of employment sponsorship, which I believe since the November 2023 announcement of expansion on the employment sponsor visa, it will definitely become a major trend in the future. By means that the skilled migrant will require to see employment and work in Australia in order to become a permanent resident, which is good for the economy and also good for the business side anyway. So let's have a look what has been the new implementation of the law towards the employer. Now, this is not too new. It actually came in last week. It's about the strengthening of employers' compliances. Now, by means, it basically wanted to ensure that the employer doesn't breach or having some sort of conducts that is not the aim of what the visa scheme was actually designed for. For example, employer arranged visa for employee. Now we're going to talk about that, how that will actually be affected, but let's have a look at the law first, because there is would the recruitment company getting somebody into an employment is also counting as an arrangement as well? But let's have a look at what the law actually says. All right. So the Migration Amendment Strengthening Employer Compliance Act 2024 enacted today. That is the day of 22nd of February, a couple of days ago. Modified Migration Act 1958 to bolster mechanism in ensuring employer adherence. This legislation introduced several key features. Now, provided that throughout years, this has been about 20 years, there has been so many compliance has been enforced. Now, utilizing more legal and technological ways to enforce this, I think we're getting a very, very close and a strong, solid policy for employer sponsor visa, where it could actually balance up between employer and employee for potential employment exploitations, and also catching on those troublemakers, or the wrongdoers. All right, so the first feature is the new employer sanction implement action against employer who coerce or improperly, so that they force, that means they force the employee, the employee is either lawful or unlawful non-citizen. I'm not too sure how they're gonna deal with unlawful non-citizen. That means people without visa in Australia, okay, into accepting an employment arrangement that violate visa condition. Now, if they are an unlawful non-citizen, they don't have a visa. But anyway, negatively impact the immigration status and penalty, including jail time and fine. So if we refer to the actual piece of law, and let me search on the keyword of imprisonment, okay, so the jail time could be up to 2 years. That means if the employer does the wrong thing, okay, something that they coerce the employee into some of the work, so it's more like a slavery. Okay, it's 2 years, or perhaps asking for money. Okay, things like that. will end up with imprisonment for potentially up to 2 years. Now I think that's there's a 5 years one. I'm not too sure what this one is. Repeal. I'm sorry. That means it's gone. There's no more 5 years. So no 5 years. So it's all 2 years anyhow. And so this one has been repealed. All right, let's go back to here. Now the second feature is prohibit employer set up a system to designate individual or organization as a prohibited employer failing to adhere migration law, especially regarding migrant workers. Sanction criteria of this designation include previous violation and extent of non-compliance with prohibited employer facing restriction on hiring certain non-citizen or substantial penalty for breach. So it basically follows the I think the recently ASIC, okay, the authority for registering Australian companies are required to have or directors to register themselves, director of any company in Australia to actually register themselves. So just to find out there's no somebody has acting as a director with the unknown or for whatever the reason that is against the law. So I think that's probably what that system is all about. So if you have done something wrong, you have some bad records, you probably won't be able to become an employment sponsor for any type of visa in the future. All right, number 3, penalty and adjustment. Standardize and enhances penalty to work-related infringement within the Migration Act, including introducing imprisonment and including fines. So that's what we have just seen. So the 2 years, not this one, hold on, let's go back there. So 2 years imprisonment and also 360 penalty unit. That's about, last time when I checked, I think it's about $100,000 in the fines. So that means if you read that properly, it says or if you pay up the money, 100,000. Okay, unless there's something they can make over than that, then you go into the jail. And it says or both. So that goes down to how serious the conduct was. Okay, number 4, enforce undertaking for work-related violations, especially in procedure enforcement and undertaking allow and resolve compliance dispute outside of court. Now that's really you probably don't understand even if I read it, but I'll explain later. Okay, compliance notice of work-related violation. Explain how authorized officers can issue compliance notice to employer not fulfilling their duty. Outline necessary corrective action, setting up penalty and failure of compliance. So that basically giving the right for a particular immigration officer to issue a paper that's a legalized documents for particular employer saying, look, you need to provide this, otherwise you will fail this and fail this and fail this, and if that's what's happening, that's the penalty of it. So they'll provide a written, in other words, they'll provide a written information in regards potential violation or breach of the law. Okay, the last but not least, additional amendments make various changes to refine functionality of Migration Act, including adjustment of delegation authority and elimination of specific act sections. So that's pretty vague. So at conclusion, this legislation underlined the Australian government's dedication to safeguard non-citizen from employer exploitation and ensure a non-compliant employer faces stern repercussions. It seeks enhancement of migration system integrity, align penalty enforcement, blah blah blah, and goes on. So let's conclude. It's why am I doing this video? It's basically giving people more of the transparency and information in regards to the upcoming trend, which is going to be the employment sponsored visa. However, over the past 20 years, because there has been numbers of exploitation by the employer, for example, modern slavery, asking for people to work whilst they pay the employer, which is all the wrongdoings. Now, this seems to be all closed loop. Now, the question I have for this kind of legislation, as you know, there has been an enforcement of law on people trafficking and things like that, and people coming on boat and things like that. As long as I don't know how far it can go, but there's still people coming unlawfully arrive in Western Australia, and that has been there for past 20, 30 years. Now, whether or not this law enforcement, well, obviously it's a piece of document that will add on towards the new employment sponsor scheme that's going to be introduced later this year. However, would it really stop it? I don't think so, but at least there is a way to treat those problems. So there are people, there are officers giving the rights to issue written notices and to fine the employer or to put them in jail if requires. But I suspect there were still people conducting those things. Now, key differences here is my question is, how would they actually define arrangements? So it will be, there will be a gray area where recruitment companies, do they count it as arrangement as well? Would these recruitment company also breach those, those information? So if there's a third company, it's recruiting employee to an employer, and obviously they get cuts out of the employer or employee sometimes, does that breach the law as well? If this employee is actually a skilled migrants, not local employees. Now, how would that work? And what if it was a successful recruitment from a recruiter, putting somebody lawfully working at a company A or company B, and there has been a dispute and complaint afterwards? Would this trigger this law as well to actually check the integrity on the employer, or perhaps on the third party, the recruiter? This is $1 million questions. Now, obviously, if the employer has not conduct any way of coercions, so if there is no other evidence of showing that the employer has actually receiving financial benefits out of this, well, if that happens overseas and with another third party or fourth party, could this still enforce upon? Question marks. But anyway, if you are coming into Australia with an employment visa, you better have all these knowledge equipped. And we can't say too much, but this is more protective law for the employee, and you need to have that knowledge. Again, if you don't have the knowledge, you cannot protect yourself. If you have the knowledge, then you have some way to protect yourself anyway. Should you have more question, query, more than welcome to leave comment right down below. That's your next video. Goodbye.